Good morning and welcome to Senate Corporations, March 2nd. Bills we're going to take up today, continuation of Senate File 46, Air Ambulance, Senate File 86, Attorney General Elected Official, Senate File 102, Unclaimed Cooperative, and we'll take a couple others up if time pending. We'll bail right back in. We'll do roll call and then bail right back into their ambulance continuation. So roll call, please.
Senator Boner,
Excused.
Senator Case,
Present.
Senator Nethercott,
Here.
Senator Scott,
Here.
and Chairman Driscoll.
Here. We have a quorum, and I don't remember where we left off as far as testimony on the air ambulance. Who did we have?
I think it's Senator Scott or Senator Case's bill. And
Right.
so maybe we can go back to him and have him remind us where we were. And
Senator Case, you have the floor. Take off running.
Well, thank you, Mr. Chairman. I'm very glad to be here, and I appreciate the accommodations for my not being present in person. Mr. Chairman, we were discussing the air ambulance bill at the close of our last meeting. I think Senator Scott was going to do some research and try to figure some things out. And Senator Nethercott had been very gracious about pointing out that there is another bill in the House. And I believe it's passed the committee of the whole. It's quite an extensive bill. It involves, it's about 22 pages of detailed consumer protection issues. So for me, Mr. Chairman, it's kind of a, I sort of prefer regulation light. It's my nature. And I think simpler is better. So I hope you will support the bill. We do have another option coming from our friends down the hall, and you may choose to go that way. But I do really believe that this market, just with some very light restrictions, can work very well. And with that, I'll maybe save time for later. Today, Mr. Chairman, I'll probably not be with you the whole time. And I hope to be with you in person in the morning.
Appreciate that, Senator Case. I will do something that you didn't do for me. I'm going to leave votes open for you. I trust you understand the bills. And if you would like to call or email or leave votes, I will allow that. I'm not getting even.
Mr. Chairman, I appreciate it, and I appreciate the good spirit you offer that. I'll probably decline, though. It's okay, and it's not a worry to me. So thank you very much, sir.
That is absolutely your option, so thank you.
Yeah.
Welcome, Senator Boner.
Oh, sorry, I'm late.
We're good. Proceed on, Senator Case.
Well, I don't know if anybody else wishes to testify. Remember last time we had a presentation from a couple of providers, or one provider or two people, and the AARP. I know that they're still with us. Mr. Laycock is around, but I don't know if he wishes to speak again.
Does anybody want to come forward and testify? Come up, please. Welcome. Good to see you, Mr. Jensen.
Yes, Mr. Jensen, when the microphone turns green, that's when it's on.
Thank you, Mr. Chairman, members of the committee. My name is Bob Jensen. I'm a government affairs person with the law firm of Holland and Hart, and I'm here to talk on behalf of the company Air Methods today. Appreciate the opportunity to have a little additional public comment. Air Methods is another large air ambulance company that operates in the state and does not sell memberships to people that they carry in their life-saving vehicles. Our interest in this bill, of course, is primarily consumer protection. And we just feel like there's a strong need for both disclosure requirements on the sale of these memberships, as well as financial accountability requirements and the oversight of their financial operations, just like the insurance department does for a lot of other products like this. And in particular, the reasons for that are recently the federal government passed what's known as the No Surprise Billing Act. And that will dramatically impact the cost and the additional billing that had come from some air ambulance companies to people that utilize that service. So that is going to dramatically lower the need for products like this. And we feel that it's important for people to understand not only the Medicare issues around disclosure, but also the requirements of the No Surprises Billing Act and the impact that will have on balance billing procedures that some air ambulance companies have done. So we think that that's a significant reason to have stronger financial oversight of companies that sell these memberships, and not saying that they don't have a place and people can't buy them, but they should know where and why, and they should know exactly what it will cover and what the need for the product is. With that, I stand for any questions. Thank you.
Further public testimony. Further public testimony. Public testimony is closed. Committee, what's your pleasure?
Chairman, Mr. Chairman,
Yes.
we have some for public testimony on the Zoom.
Oh, perfect. I cannot see from here. So,
I'll show you.
yeah.
Mr. Tom Laycock is on.
Okay, welcome, Mr. Laycock, Senate Corporations.
Thank you, Chairman Driscoll. I very much appreciate the opportunity. Last meeting where you folks were discussing this issue, I think at the time where we ran up against the time limit, AARP had just suggested two potential amendments. The one is just discusses the fact that folks may already be covered for air ambulance services through their health insurance, including Medicare. And we suggested before signing the agreement, you're advised to consult with your insurer to determine if you're already covered and what services are covered. And the second one was what we refer to in our office as the bird you buy may not be the bird you fly, which just says that you should know that blank company may not be the company called in an event of an emergency situation. You may be responsible for the entire bill if a different air ambulance company provides this service. And then the last piece of that too is we think it's important that people know that before they sign. I know House Bill 7 on the other side had an amendment that was brought that would require air ambulance companies to notify their clients of this, but 5 days after a sale was made. We think it's probably a better idea for folks to know that up front, and that would be our simple ask. So I thank you for the time.
Good question. Thank you, Mr. Chairman. Mr. Laycock, thanks for being here this morning. Following up from the requested amendment from AARP from last meeting and what has happened with House Bill 7, are there any differences between what you had requested the last time we met to be incorporated in Senate File 46 to what was amended into House Bill 7?
Mr. Chairman,
Mr. Laycock.
Senator Nethercott, the answer, I think the one big amendment that we saw that we would like to be moved back was simply industry had asked that instead of notifying folks right away that they may have coverage and the helicopter that they receive may not be the one that they have membership with through. We would prefer that be listed ahead of time, at the point of sale or at the point of the marketing proposal. Right now, it got amended into the air ambulance company must send you that in the mail 5 days later. I'm not sure. There are a lot of disclosures. You don't go smoke and then have the tobacco company send you a disclosure 5 days later. When you're buying a house, you tend to find out that stuff up front as opposed to 5 days later. So we just like to move that date up to the point of sale.
I can't hear. I'm not hearing any audio. Can't hear a thing.
Mr. Chairman, this is Amanda with LSO. I believe the committee secretary needs to unmute herself on the Zoom so we can hear the room.
Maybe we could replay the last couple of minutes.
Mr. Chairman, Judy, if you unmute yourself.
I did that. She is unmuted.
Not her personal, but the one that actually says committee secretary co-host.
Got it. Okay, so
Not hearing anything.
Mr. Chairman, this is Amanda. I'm heading up to the meeting room.
that off too.
Look out, you guys are in trouble.
Can you hear us now?
We can hear you, but the audio quality is bad with an echo.
We're gonna have to cope with it.
Okay, we can hear that.
Everything's
I think housekeeping is here. I'll be right back.
Temporarily apart. There you go. Did you catch any Mr. Laycock's testimony on your case?
Well, I'd call for the question. Just joking.
Senator Case, did you hear Mr. Laycock's testimony?
I did, I think.
Great. And so the only testimony or discussion you didn't hear was Senator Scott.
Did not hear
Before we
Senator.
start again with him, we need to move the bill.
Yeah,
Senator Scott was speaking, he's on and against the bill. So
Right.
he doesn't want to move. the
we
bill.
didn't want to hear that.
Oh, Generally, for me, chairing a meeting is I have the bill moved before the committee discusses.
Okay.
So I'll let Senator Case move.
I'll move it. Let's- Not hearing anything.
Does this work?
We can hear you.
Speak now.
Okay.
None on.
It's on now.
It's kind of echoey and there's some feedback.
Yeah.
I'm done.
But Senator Scott, if you're going to speak against the bill, the feedback's okay. Now we can't hear anything. You guys, I'm okay if I just drop off, honestly. I trust you and I know I really trust my colleagues. I don't want to argue with you. So I would vote aye and you guys can discuss. I support the amendments of AARP and leave it at that.
Refusing to accept workers' comp claims. We took that to the 10th Circuit twice. And what goes on here, and we lost both times, is the federal government has prohibited with the Airline Deregulation Act, the state from regulating air ambulance rates. And we were getting people that were having tremendous bills, 50,000. We had a member of the committee who had a 50,000 bill for one transport from Rock Springs to Salt Lake City. It actually happened before she was a member of the legislature. We were looking for a remedy. The simple remedy was to regulate the rates, and the feds had prohibited that, preempting it as interstate commerce, in the same mode as airlines. And of course, with airlines, you've got a choice. They get the prices out unreasonable, you can go with the competition, and people do. Not true in air ambulance. You don't, most of the time, you don't have a choice as to which air ambulance provider you use. We were hearing complaints as well that there were a number of air ambulance companies in the state, and some of them were selling memberships that appeared to be insurance, but they only covered if your company happened to be the one that was called. So we eventually put a provision in a bill that was really is a sort of auxiliary provision, asking them to register with the state insurance department if they were selling memberships, because these were essentially being viewed by the public as a form of insurance. And in fact, I think we're being sold that way, even though they didn't use the words insurance. And people were getting surprised when they didn't have coverage. We'd heard of that, and we hoped that maybe the insurance department could use some of their consumer protection powers to protect some of these consumers. What happened was we expected everybody to register, and then the argument over how much protection we could really offer would proceed from there. In fact, we had a real insurance company who was in the business of selling air ambulance insurance register, but the other companies chose not to and initiated a massive call your legislator campaign instead, saying they could no longer offer the products, which they couldn't because they wouldn't register. We talked, the insurance commissioner testified at the virtual meeting to the number of calls they got. My name was on the list of people to call too, and I found my phone system unusable for any other purpose for about 2 weeks. It was really overwhelming. But I talked to a large number of people. And one thing that emerged in a hurry was that the majority, I think the insurance department figure was 80%. I never kept a close tally, but it was clearly a majority of the people that called were on Medicare. Now, when the feds exempted the air ambulance people from having their rates regulated, they allowed Medicare and Medicaid to regulate the rates they paid. So the feds were protecting themselves. And what the bill that we had caused the registration to occur in was one where we were trying to get Medicaid to allow us to regulate using their abilities, which they ultimately refused to. But talking to the people and inquiring on Medicare, it turns out that Medicare covers the air ambulance service, regulates the rates. You can be billed 20%, but only 20%. You can't be billed for the balance of what they charge. The Medicare regulates that. And most people have a Medicare supplement insurance that covers that 20%. There are a few that don't. I think I talked to one that did not. But most of the people that are on Medicare, and almost everybody over age 65 is, they cannot use these memberships because Medicare covers them and won't allow a balanced billing. There's no way they'll get a claim. There are some, Medicare being bureaucratic, there are some restrictions. It has to be a genuine, there has to be some reason to call them. You can't just do it for your convenience. And the regulation is you have to go to the nearest place that can handle the emergency. Well, you probably mostly want to do that anyhow. Not always, but mostly. But we were essentially uncovering a lot of people who were being sold a product that they would never be able to use. We thought, Mr. Chairman, I think the regulation is a good idea. I think they should register with the insurance department. I think they should come under some of the consumer protections there. And this bill, as I read it, would undo that. The alternate bill over in the other house, if they will send it to us, is probably a significantly better vehicle. That was worked over carefully, and I understand from the insurance department and from taking a quick look at it that it is probably a superior solution than this one. And I would strongly urge us to let this one sleep and see if we can fix it the other way.
Committee, further comments?
Mr. Chairman, if I can respond.
Senator Case.
Thank you very much, Mr. Chairman. Mr. Chairman, I think the people in my district, which really includes central Wyoming, I think they're more affected by this regulation than other people in the state of Wyoming. I'm pretty convinced that most people in Fremont County and up into the Bighorn Basin probably have felt the need for transport services than other folks maybe in Casper or Cheyenne or closer to other areas. Mr. Chairman, they want this bill, and they do understand the difference between memberships and subscriptions and insurance. They truly do. And I think with the disclosures about the Medicaid, great idea, perfectly good suggestion by AARP. And I think we should do that. But I strongly disagree. You know, I feel that we're being punitive and that the last bill was kind of punitive about companies operating in the market. And to expect them to go and become insurance companies, I think was a ridiculous notion. I do. I think they, you know, I compare it to the services you might get from a local tradesman. Pick a plumber. You know, a plumber can work and provide you with a service contract where for a monthly fee, they'll fix anything on your property. But yet, in the middle of the night, if you can't get your first plumber, you have to call someone else. You don't expect your first plumber, the service contract, to pay the second plumber that comes and fixes the leak in the middle of the night. People, I think, understood this mostly perfectly well. I certainly agree that there were exceptions, but to think that a company that wants to provide basically a service contract should now take that same service contract and let it be called insurance so that they underwrite the services of their competitors is pretty naive thinking, and kind of I think we just made a mistake. We kind of ignored something in the market and we wanted to be punitive. This is a way to back off in a way that my constituents truly want. They truly understand it. I'll give you an example. There's a benefactor in DuBois, Wyoming, who bought memberships for the entire town. The county considered doing it as well. Many people have memberships or would like to have memberships for both air ambulance companies that serve the area. They understand. And you know, if we can clarify the balance billing or the Medicaid issue, we've done a great service, and get it out of over-regulation, because once in a while, the heavy-handed regulation isn't the right approach. Thank you, Mr. Chairman.
Thank you, Senator Case. Further comments from the committee? Senator Scott.
Mr. Chairman, let me make very clear there was no intention of being punitive when we put in the registration requirement. And our intent was mostly finding out who was there. We were surprised when the companies did not register. It was a minor issue in that bill. The companies had lobbyists that watched the bill. We never heard that it was going to have the effect of excluding them from the business. Frankly, what I think happened was that when they really looked at it after we'd passed the bill, they decided that their policies would not stand any kind of regulatory scrutiny, what their practices were. There's a big difference between the plumbing example that was just cited. You've got a choice. And if you choose somebody else, you know. With air ambulance, we found on investigation, you don't have a choice in who comes. You need you have an auto accident or accident in the backcountry, you need an air ambulance. The 911 dispatcher sends whoever is most available. And in a crisis, that is a very rational way to do things. You have no control over it. In the setting where you're being transported from one hospital to another, and that's a major part of the business here, we have a committee member, it was Fred Baldwin, who often was the one that called these people. And he told us that he never knew who had what membership or insurance, that much of the time they were using whatever carrier the out-of-state hospital, and in his case, it was mostly out-of-state hospitals that they're being transported to, sent. But when he had to find one, it was again, who can come now, and didn't have anything to do, and he had no knowledge of any insurance or membership contract or anything else that the patient had. So people just don't have the choice that it takes to make a marketplace work. So again, I think the current situation, you can buy the insurance if you want to, and it'll be real insurance, or you cannot, but we'll put a stop to it does put a stop to the selling of memberships that don't do people any good. And I think that is a major problem.
Thank you, Senator Scott. Further testimony?
Mr. Chairman?
Senator
Wrap it up.
Case, fire away.
You bet. I just wrap it up. My people do understand that these are memberships. I think it's very big leap to have a company offering membership qualify to offer insurance that would pay for your competitors. Insurance regulation is light years different than this, and that's what happened. These companies don't want to sell insurance. They want to do what's accepted and used in a lot of states. And you may not like it, but the market works fairly well and would work better with the disclosures that we're proposing in here. I certainly concur that there's been problems, but I think in my neck of the woods, people do understand it, and the proof is in the fact they actually get 2 memberships, and it's actually cheaper than the insurance products that are available on the market. Thank you for your time, Mr. Chairman. I do understand. I'm very grateful for the committee's indulgence on this. Thank you. Thank you, Senator Scott, for your comments.
Thank you, Senator Case. Are our amendments passed? We passed them, correct? We did not. Okay. Senator Nethercott.
No, Mr. Chairman, we haven't had an opportunity to work the bill. It was moved by Senator Case. I think discussion has been ongoing. Senator Case supports the bill. Senator Scott does not. So I think we're ripe for amendments if we choose to move the bill, continue to work the bill.
So we're kind of through our comments. Do we have amendments bringing forward anyone on the committee?
I'll offer the AARP amendments.
Okay, we do not have those in front of us, I don't believe. Senator Nethercott.
Senator Case, do you have the amendment? If not, I can find it. I've got it.
It might be easier for you. They were, AARP gave them to us at the last meeting.
They did.
For the public's benefit, this is what the amendment is. I'm not entirely sure where in the bill, but this is the language they would like to be amended in, creating a subparagraph B wherever that would be appropriate. So perhaps look in your bills to find where this would be dovetailed in. For a subparagraph B should read as follows. All air ambulance transportation memberships and subscriptions offered in this state shall be provided in writing. All memberships and subscriptions related written advertisements and marketing materials and annual notices to existing members shall contain the following language, highlighted in bold in not less than 14-point type, and states the following. This agreement for air ambulance transportation services is not an insurance contract and is not regulated, monitored, or reviewed by the Wyoming Department of Insurance. The business practices and financial condition of the person or company offering this agreement may not be reviewed or regulated by the Department of Insurance. All caps. You should know that, insert name, may not be the company called in the event of an emergency situation, and you may be responsible for the entire bill if a different air ambulance company provides the service you may already be covered for. Air ambulance services through your health insurance, including Medicare. Before signing this agreement, you are strongly advised to consult with your insurer to determine if you are already covered and what services are covered.
Thank you, Senator Nethercott. That would go on page 2, starting line 10. It replaces existing language in the bill. So if you go to page 2, comes in at line 10 and replaces subsection small b there. So did you move the amendment, Senator Case?
Senator Case did, yeah.
Just exactly as my good colleague discussed it.
Okay, further discussion on the amendment? Question being called, all in favor of the amendment, raise your hand. Okay, that's unanimously passed. We're back on the bill. Any further amendments? Any further amendments?
Mr. Chairman, I'm trying to recall, but if we could ask Mr. Laycock if we got it all.
Mr. Laycock.
He gave a thumbs up, Mr. Chairman.
Okay, I didn't catch that. Okay, we're back on the bill. Any further discussion on the bill?
Question on the bill, Mr. Chairman.
Question on the bill. Roll call.
Mr. Chairman, I got that Senator Case moved the bill, but I didn't get the second.
I've been running without a second, but I can do it myself.
Okay,
I think I have the latitude to make it where the committee doesn't have to have a second, if that's all right. with the
Mr.
committee.
Chairman, small point of order. I think that's kind of a committee decision. The chair can make the decision unless the committee wants to override it. When I was corporation chairman, we didn't require a second, and that's entirely up to you and the committee.
okay, I didn't understand that.
I'll
Thank
go
you.
with the pleasure of the committee.
Mr. Chairman, I think it ought to be at the chairman's discretion. I know I never asked for a second on a 5-member committee.
I feel that way. So unless anyone else has a problem, it just requires the motion. If it's your personal bill, it's like Senator Case. I like seeing the bills heard. So
Thank you for the clarification.
that's my bad. Thank you. So roll call.
Senator Boner,
Aye.
Senator Case,
Aye.
Senator Nethercott,
No.
Senator Scott,
No.
Chairman Driscoll.
No.
So the bill fails, 2 ayes and 3 noes.
Thank you.
Thank you, Mr. Chairman.
Next bill up will be Senate File 86, Attorney General elected official. I see we have Senator Bouchard. Would you like to go up front and present? If you can do it up here, it'd be better. Thank you. Thank you for the work on the last bill, Senator Case.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you, Mr. Chairman. I'm here to present to you Attorney General elected official, Senate File 86.
Can you identify yourself first for the
Yeah.
world out there?
Thank you, Mr. Chairman. This is Senator Anthony Bouchard, Senate District 6.
Thank you. Proceed.
So this is a bill to shift the Attorney General away from the governor's office and as an independent elected official. Before I go over the bill, can I have the latitude to explain why I think this bill is important?
I'll give you you've got the floor and you proceed in any way you.
Thank you, Mr. Chairman. There was a case a few years back where there was a doctor that had committed fraud. And what was really the problem is that the AG at the time was friends with the doctor. And the smoking gun was that the AG actually admitted that he was friends on the swearing in. I have the audio and I will make that public if needed, but I have the audio where the AG actually acknowledges the doctor as his friend. Later on in the case, when this thing developed and the investigation happened, we don't know for sure who was the one saying to stop the investigation, but we do know that it was under the control of the governor. The AG was involved and people in Medicaid division. So everybody was kind of complicit in what happened. They fired the investigator. The case is a federal case where the investigator actually turned evidence over to the feds. Sadly, they fired his wife as well that worked for the state. I mean, financially hurt the people involved. It was a bad deal. So, I mean, I've got all the evidence to back all that up. I did not bring it, but if it's needed for the committee, I certainly will provide it. I think that we need to start making sure that this can't happen. I think that the Attorney General should be accountable to the people. And I think we have a way of where the Attorney General is working not as much for the people. There's another case where we had a guy that was stopped in a place of all places in Freedom, Wyoming. He was stopped on a motorcycle with a firearm, and the only thing that he really wanted was from the sheriff's department after he was stopped for 45 minutes or so, is he wanted remedial training to the officers. They would not do it. It ends up going to court, and he has the full Attorney General against him. And it goes to federal court, and we lose. We actually lose something where we have a right to carry, and yet the officers were able to detain a man without any real reason to do it. And so we had, again, there's a case where we have an AG not looking at, I think if they were elected, they would look at the case and go, wait a minute, maybe we shouldn't do this. We're going to lose things for people. So anyways, let's go out of the bill. So I'm not going to go through everything on page 1. This is just everything that's happening in the bill, which is we're going to see everything that an AG does, I think, by looking in here. I do want to note that the AG is excluded in this bill from the slip board. I think that it's a good thing for them to be separated from it, so that way they're not part of something that they could be a conflict in. So on page 2, it starts out on line 8, there's appointment. You'll see on line 16, or actually you'll see on line 11, there's where it starts making transitional language through line 16. It has the time it would start. On line 21, more transitional language. This is all going to have to work in multiple places, so it happens. And at the end of the bill, you'll see some of it takes place at one date, some of it takes place at another date when it finalizes in the bill. On page 3, more conforming language about following the general election in 2022. The term of the Attorney General appointed under this section shall terminate the first Monday in January next to the following general election. That's the first section. On line 11, page 3, there's the appointment changes that will take place. On line 21, more conforming language. You'll notice that this is similar throughout the bill, where they cross out the 5 elected and either add the AG or different language that's talking about the AG. Next page on line 4, we have elections starting on line 7. More conforming language. As we go through this section, you'll see what it does is that general election. It's in that section where all the other elections are. So that goes to the end of page 4. Page 5, more of the election language that's conforming. On line 6, order of listing the offices in partisan elections. So it's starting out on line 14, the Attorney General is included in that list. Section language 2 is just all the statute changes. On line 6, talking about negotiations and purchase, scope of purchase, taking it from the governor's office on line 17, and actually moving the report annually to the Joint Revenue Committee and the Joint Judiciary Interim Committee. So this is a shift of executive power on page 6. Going on to page 7, more of the same, commencement of action. So we're getting rid of when directed by the governor and scratching that and moving it over to basically giving the Attorney General that where they may commence action because they have full discretion in this bill to do so. There is obvious on line 12, you'll see it says a county attorney shall commence action when directed by the governor. So there's executive power retained there on that section. On line 16, violation of contracts and how they're reported. If you go to the next page on 8, you'll see that it's more conforming language or just shifting the power from the governor's office and approval to the attorney general. Line on page 8, line 16, power to investigate and execute actions. You'll see on line 21, it's full discretionary power is given to the attorney general. On page 9, more of the language to change the remove approval of the governor and giving it to the attorney general. On line 7, appointment to on joint commissions. So the on line 7, it says scratching the governor shall appoint the attorney general, and so more conforming language. Same thing on line 22, definitions, more conforming language. On page 10, you'll see it on line 11 and line 17, where we're scratching 5, and then there's including or adding 6 elected. So more conforming language. Line 11, the same thing on starting on line 1 and 2 and 15 and 16, more conforming language there. That is in a section for authority to contract as well. On page 12, monitoring right of access. This is monitoring all aspects of private contracts performance under a contract for the operation of a facility pursuant to WS 722-102. And so basically what's happening here is the individuals that are employed under or with a contract will be under the purview of the additional. So where it says on line 11, it says 5 and it includes the 6. So it's just adding another elected in the monitoring. Page 13, we have definitions, more conforming language. Line 14, we've added attorney general. Distribution of statutes and supplements and session laws on line 13, or I'm sorry, page 13, line 17. There's just more conforming language on the next page for that, adding 6 to the 5. As we go through page 14, more conforming. Actually, at the bottom of line 14, we have vacancy of office and successors. So it's included here on on page 15, line 4. You'll see the attorney general is added. Vacancy, there's language here on how a vacancy will be handled on the bottom of page 15. More conforming language on 16. You can see the change on line 7 with approval of the governor has been scratched. And then it says the attorney general may retain qualified practicing attorneys. Page 17, starting at line 1, more the same. The attorney general investigate any matter in a county of the state. So conforming language. 17, line 10, prohibited practice, conforming language, scratching appointment, and adding election on line 16. On the bottom of line 17, or page 17, starting in line 19, approval of public securities and official bonds, rights, proceeding, investigation, misconduct. Everything has been shifted here in the following page. So page 18, You'll see on line number 1, it used to say under discretion of the governor. It says the attorney general shall institute and pursue proceedings. So all these are a shift on, same thing on line 6, conforming language, line 15, upon complete investigation, the attorney general may institute, he has full discretion. Line 19, assistant attorney generals, there's a shift here, the same thing, conforming language, allowing the attorney general to have that full discretion of who they're going to appoint. And on page 20, there's a shift on DCI as well. The Attorney General shall appoint a director who is chief administrative officer and the chief agent of the division. So, I mean, this is a shift to the top cop, basically. He's in charge. I think it's a good way to be. I think we got to get politics out of enforcing the law. On page 20, line 11, the Law Enforcement Academy will stay under the governor's purview. So it will not shift to the Attorney General. So in other words, the Law Enforcement Academy will still stay under the governor, so that he appoints. Are there any questions?
Senator Boner. Got pushed really hard.
Right, yeah, well, you know, somebody says law enforcement academy, the guy from Douglas is probably gonna pipe up, but it's my understanding that, well, the law enforcement academy is currently under the Attorney General's office. I would think that if we're letting this be an elected official, we'd give them more responsibility, not shift it to the governor. It just seems that it's a little awkward to have the governor kind of reaching into the AG's purview and deciding who the director of this one portion of the AG's office is. And if for me, my inclination would be to just remove the governor from the equation, let the Attorney General make the decision who's heading up divisions within their agency. So just a little bit more explanation would be helpful for me.
Mr. Chairman, Senator Boner, I don't have heartburn either way on that. I mean, there's a lot of things that go on, as you know, formerly being on health. There's a lot of things that wouldn't be covered under maybe the direction of an AG that has, you know, there's a lot of things that happen. There's a hospital, there's psychiatric, there's other things in that division. So I don't have heartburn either way, but I think that there's some of those appointments that maybe need to be done by the governor. And I think as we move into a shift too, we're going to see things that we need to do better. I don't think it all has to happen on this first swoop, if that makes sense. Does that answer your question?
Senator Boner.
Yes.
Senator Scott.
Mr. Chairman, a number of other states have elected attorney generals. I don't know what the balance is between elected and non-elected. I think there's more that are elected than there are non-elected. My question is, have you looked at the practice in the other states that have elected attorney generals? The ones I'm aware of, you wind up having to have an appointed legal counsel for the governor and the executive branch so that they can have their own lawyer to consult with when they really need legal advice on a tangled thing, and not somebody who would be a potential political rival. My question is, do you know, is that all the other states that have attorney generals? Is it most of them? What's the experience been elsewhere?
That I don't have an answer to that question, but I do know that we have a shift in this to allow such. I'm sorry, Mr. Chairman.
You're good.
I overstepped there.
You're very good. Go ahead.
And so, Senator Scott, there's a shift in this to allow for a timeline of that to happen where they have counsel. I still, as I read the bill, I look at it, we'll have to come back and maybe do that and allow counsel in the governor's office. But I do think, and maybe we just have to look at, isn't there a provision already for the governor to allow him to hire counsel? I mean, I would think as an executive, he could do that. So.
Mr. Chairman, no, I will say, I do think this bill will have a significant fiscal implication because I think we're essentially creating a new office that we're going to have to staff. And I wonder a little about the wisdom of that, but that's.
Questions, committee? Continue on, Senator Bouchard.
Thank you, Mr. Chairman. As I go down the bill, I'm going to skip past page 20. So on 21, the director may employ assistants, instructors, and other personnel. This is a language that was already there. We're just shifting the on line 2 from Attorney General and removing the consent of the governor. So it's all shifting it to, I'm sorry, let me start over. On line 2, other personnel approved by the governor. So that's back to where we were in the criminal, let me make sure, Wyoming Law Enforcement Academy. I'm sorry. I got sidetracked here since we got off the subject. So this allows the governor to appoint in the Wyoming Law Enforcement Academy. And like I said, this doesn't give me any heartburn if we move it. I think that there are some things that are better off left separate from the AG who's also prosecuting. And the reason is because I think if they have to, for instance, hold them accountable as well, then they weren't the one making the decision, if that makes sense. On line 11 of page 21, AG is in charge of victim services. On line 15, page 21, we just scratched with approval of the governor, and then it says the attorney general shall appoint a director of victim services. Going on to page 22, more conforming language on the same subject. And then starting at line 5, general services division, more conforming language. You can see it on on line 14 to page 22. Salaries amount. Basically, this is salary of the AG. When we go to page 23, you will see that there. That amount, I don't know how LSO did that because it looks like it's actually $175,996.64 currently. So we would probably have to at least change that or look at where the law is that actually has that provision. I have no heartburn of increasing this amount. I want to attract the best to this job. So I think as I look at other employment and salaries, we've got some other salaries that are much higher than this in positions because we are attracting, to attract the best to the positions. So I would even bring an amendment to increase possibly. So on this whole section, on the next part of the bill here, page 23, line 6, the natural resource policy account was created. There are no changes that I see in this section. Well, let me rephrase that. When we're looking at this section specifically, it leaves the governor. So if we go to it on page 23, it tells you what that section does in the law. When you go to 24 on line 1, the governor may expend funds from the federal natural resource policy account. So I mean that's still staying under the purview of the governor, but it also has in carrying out this subsection the attorney general or the counties with approval of the governor. So I mean it's any questions? No? Thank you. I'll proceed. Mr. Chairman, on page 25, more conforming language. Disclosure, same thing, scratching 5 and going to 6. Page, at the bottom of page 25, the Second Amendment defense, and some of you may remember when we added that. It has conforming language on page 26 to 11 to remove the part where the Attorney General shall obtain approval of the governor. So this is a pretty substantial shift in the protection of Second Amendment rights with a elected official. I think it should be noted that when an official doesn't do something that you want them to, you don't have the ability to sue an official. If it goes to court, that what they basically will tell you is that you have a ballot box to address your grievances. This actually would align, this bill aligns it. If you just look at this section alone, we've had several cases under the previous administrations in the federal government where they were coming after guns that we could have won on some really hard cases on this. I think we're going to see that happen again under the new administration. So anyway, I'll move on here. So as we go on to page 27, there is other part here on federal. I'm sorry, on page 26, on line 17, take action on Federal Environmental Protection Agency. Again, I think this is some of the things that we've had issues with our minerals and coal and oil. And I think this is going to make it different, or an elected official who's accountable directly to the people and not stepped underneath the governor would make different choices than we've had. And you can see it on 27. It also conforming language on line 2 before intervening or initiating has been removed, so the Attorney General has a direct discretion to take such action on environmental issues. On line 27, or on page 27, line 6, Attorney General to commence action. We're just shifting on line 10 the power from the governor to the Attorney General. More so conforming language as we move on, vacancies and other offices on the bottom of 27 going on to 28. Just conforming language there on vacancies. As we go down to state agency plans, to the legislature contents and purposes, more conforming language there as we go on to page 29. You'll see it says on line 2, of 5 is crossed out, and then we've added the word Attorney General line 4. As we move down that page, Senate consideration on line 7. So this has to do with all of the section, how the Senate confirms in the case of an appointment. So everything in here also has the ability that if a Attorney General resigns or for whatever reason is not in office, there still has to be an ability to appoint one to temporarily serve. So this language on this part of the bill will keep that in compliance to do that. On page 30, administration provisions, there's a shift here on line 15 of 30. The Attorney General, and we've removed the consent of the governor. Page 31, more proceedings language. We have the shift there on lines 4 and 6. More of the same. We're just doing conforming language. Statewide protection order registry on line 14 of page 31. The Wyoming Attorney General, and we've crossed out the or other agency designated by the governor. It's crossed out, shall establish statewide registry of protection orders. So that will be under the purview of the AG. As we get to page 32, we have it's everything that's happened in here would that would be an immediate shift and a move to make to move it over to an AG will happen on July 1st. Everything else would happen at a later date as we move away from an appointment to a elected. So with that, I went over all the bill. I'll stand for any questions.
Thank you, Senator Bouchard. Questions for Senator Bouchard? Seeing none, thank you.
Thank you, Mr. Chairman. Thank you, committee.
Further testimony on the bill. Ms. Herman, come forward, please. Good to see you back. Thank you.
Thank you, Mr. Chairman. It's good to be back. Excuse me. Committee and Mr. Chairman, my name is Marguerite Herman. I'm here on my own behalf, not representing any group, simply as a 41-year observer of Wyoming state government. And I'm here to argue against the bill, put that up front. I will say politics can help some processes. We see it in the legislature where it makes opposing people come together, find solutions, compromise. It does get things done. And so I agree that politics and popular elections have a definite role in getting things done in state, local government. I think though, however, politics, it does not help in every case. And, the whole analogy of sausage, I would say the Attorney General's office is not where I want to see sausage being made. It's like, for instance, I was thinking about, there's a bill this session to have the assessor not elected. There's an argument for that, is now elected, should not be so. What about police chief, state engineer, the head of the Department of Transportation? You could make an argument to elect those. I would argue that they are better appointed, and I'm going to tell you why. I want the Attorney General to be guided by law and principle and constitution, legal principles. I do not, and now the Attorney General does have some discretion whether to take up certain cases or not, and I acknowledge there's some leeway. It's not like there's a prescribed activity, but I don't want the Attorney General to be engaged in horse trading. Guided by re-election concerns, fundraising concerns, about angering this donor or that political party functionary. I don't think that helps in the discharge of the duties of Attorney General. And we talked about influence, and the bill sponsor mentioned a couple of cases of undue influence. Well, I would argue that injecting politics into the office is not going to cure that, could possibly make it worse. Friendships, that, we all know that elected officials are very sensitive to that. Political animosities come into play in how they conduct themselves. Political ideology. I don't want the Attorney General to be motivated in the decisions of that office to be made by political ideology. Again, I think that politics do have a role, but just not in this position of government. I will note that attorneys general are appointed by a popularly elected governor, and they are confirmed by popularly elected senators. So there is, and it's an indirect, I admit, and there's sort of a lag time in there, but there is a voice of the people that gets heard there. Again, Senator Scott mentioned about other states have elected attorneys general. And in fact, I think most do. I remember talking to a former Attorney General of Wyoming. He said he would go to these conferences, ostensibly there to share information, professional development, and yet he and a handful of other unelected attorneys general would sit around and watch the others run around electioneering, glad handing, trying to figure out how to get elected next time. I mean, it becomes a distraction at best, I would say, an influence at worst. And so I would say that I don't think politics more politics. There is some obviously in all parts of state government. I'm not that naive, but to make it a qualification of the office, I don't think is right. It is for some parts of government, not this. So I would suggest that you do not pass this bill out. I would answer any questions.
Very good. Question for Ms. Herman. Very good. Thank you very much. Mr. Winnie, come forward. Welcome.
Mr. Chairman, Bill Winnie, Sublette County. I support the bill, but I'd like to offer the committee a different perspective than Senator Bouchard brought to you. One of the things that made our Navy's nuclear program unique was Admiral Rickover's insistence on continuity of top leadership, commanding officers, chief engineers, things like that. Another point is our top 5 leadership in the state, because of the boards, whatever that they're on, needs to remain an odd number, and I got that. But I see a weakness in our education world with the superintendent of public instruction being elected every 4 years, which can kind of be an interruption in continuity in some cases, because just the way politics works. And I offered an op-ed newspaper type thing many years ago, and people didn't like it very well, but this gives an opportunity to move towards something where you could have a superintendent that was appointed and for a long term, say 10 years or something like that. And that giving you that continuity point that I was talking about at the very top level of education. I view it as a weakness that every 4 years you have the potential to change radically in direction. Now, of course, you'd have to do a constitutional amendment to do that, and I understand that part of the picture too. So I view this as a good first step, potentially leading to something like that, leading to continuity at the top level of education in the state. And subject to your questions, thank you very much for your time, sir.
Questions for Mr. Winnie? Thank you. Further public testimony. I don't see anyone in the room. Do we have anyone in the waiting room? We do have. I cannot read her name. I'm too, Miss Murdoch, maybe?
It is.
I test at the optometrist. Welcome, Miss Murdoch.
Thank you, Senator Driscoll, and thank you, committee. I'm Charlene Murdoch. I am representing the Wyoming Federation of Business and Industry. We are a coalition of about a dozen chambers across the state. We represent more than 5,000 businesses. We had some significant discussion on this bill, and we are opposed to it, and we just do not believe this is good governance. I don't know that I follow the premise that an elected official would have less of a conflict of interest as an appointed official. You know, ethics is inherent in the individual and not how they get the job. So I think we've had some very good attorney generals. I just don't know that we've had issues in the state of Wyoming. The appointment by the governor offers the governor the ability to select an individual who has the qualifications necessary for the role. They can evaluate their track record. In Wyoming, you know, we are very transparent. And so I think this appointment process works for us. Having someone who has the right credentials as the state's top attorney is so important to the ability to bring action when necessary. And I will say, to the point of testimony, that an inference that the Attorney General has not been supportive of the minerals industry would be a mischaracterization. Prior to my role here at the Chamber, I worked in industry and in coal for many years. And I will tell you that our governors and our attorney generals have brought significant cases against the federal government and been very successful in that. I think this bill is somewhat of a solution looking for a problem, because I don't think we see it. And as we discuss this bill, a number of us who are chamber executives or across the state, we've lived in other states where there have been appointed attorney or elected attorney generals. And we didn't hear of one example in our group where someone lived in a state where that process was very effective. Generally, the attorney general might be vying for political recognition. And so a lot of times they were polarized with the governors, fighting positions that the governor needed to take. And the AG needs to be legal counsel for the governor, not vying for political power with the governor. And I think there's just a lot of risk with that. And that is very concerning to us. Agree with Senator Scott that there could be some significant fiscal impacts with this bill, as the governor then would need to hire outside counsel from a third party for legal advice. At a time when our state is struggling to determine how we're going to pay our bills and balance budgets, it just seems not necessarily good governance to be changing the way we align our top officials and the way we utilize services. So, we would just suggest that we don't need to follow the pattern of states where this model has not been effective or productive. Ms. Herman was very articulate in her comments, and I would echo her thoughts on the need for the AG to be selected on a track record of their ethics and their performance and their ability to focus on the issues at hand rather than re-election. So standing in opposition to the bill and would be glad to answer any questions. Thank you, Mr. Chairman.
Question for Ms. Murdoch. Thank you. Do we have further people in the waiting room? Okay, no one else here. With that, public testimony is closed. We're back on the bill with, I guess we're just down to the point of need to move. Bill's moved. Discussion. Here, Scott.
Mr. Chairman, Mr. Chairman, I have long thought that one of the strengths of our system was that we did not have one attorney general. It is expensive because you do wind up with dual legal structure because the governor does confidential legal advice. The rest of the executive branch does too. And with elected attorney general, what I've seen in too many other states is that elected attorney general often see themselves as a governor or a U.S. senator in waiting and campaign vigorously. And essentially do some legal grandstanding sometimes. We've seen a number of suits brought that are really, I think, because they're popular rather than because they're necessary. I don't know that would work that way in Wyoming. I suspect the causes might be different, but I suspect it would be some of that because they would have the same. They also have a concern about being reelected, as well as potentially campaigning for a higher office. You set up a rival at the top levels that I think could be not conducive to being effective in our system is. And I think the cost reason is clear. And I think by and large, the performance of our attorney generals have been satisfactory. We did have that one case. We heard quite a bit about it in committee, and because then Medicaid, he uncovered classic Medicaid fraud. And the system did eventually get the perpetrator prosecuted. There was a second side of that in terms of some of the other individuals who may or may not have been involved. But those reasons,
Further testimony. Senator Boner.
And just real quick, I do see some merit in this bill, and that appreciate the perspective from my colleague from Toronto County. And but you know, we have seen lawsuits being brought that were clearly a result of a political process, that bills being brought in the legislature, for example. I think that's still a dynamic, and maybe it's not all that bad. And you know, there has to be a balance. I understand the absolute need for a very significant focus on the technicalities of what the law, what the possibilities of a lawsuit in particular are or are not. But we also have to have a balance of being directly connected to the people and understanding what their needs are as well. So I think that this will help tilt the balance in favor of a attorney general that's going to be a little bit more responsive to what the current goings on and needs of the state are. And I think that'd be a positive improvement. So I'm leaning towards supporting the bill for those reasons.
Thank you. Senator Nethercott.
Thank you, Mr. Chairman. Since I've been in the Senate, we've addressed this bill every year, I think. And since when my very first year in, when being presented with the topic, was adamantly opposed to the issue of electing an attorney general as a result of really creating an opportunity for political ideologies to overcome the need for measured legal decision-making. And just our system works pretty well, was my observation as a practitioner in the state, as a lawyer, and had great regard for the Attorney General's office and all of the attorney generals that I had worked with. Since that time in the legislative branch, I've of course been pulled over to the third branch of government to see some additional merits associated with an elected attorney general. I am not completely persuaded that it's the right answer for the state, particularly now. I agree with Senator Scott that the costs associated with an elected AG would be far greater, and I am somewhat dumbfounded at the fiscal note, which says there would be no fiscal impact. I mean, of course there would be, and certainly there is if we created an entirely new elected position. And I also do believe that in order for an attorney general that is elected to remain elected or to fulfill the mission of the people, would be making a lot of legal decisions reactionary, not necessarily based on the fiscal considerations that potentially could be involved. That said, I do see the merits, and I do think that there's inherent challenges associated with having an appointed AG. I think this is a conversation that needs to continue. I think that it's important. And I struggle with the decision because I can see its merits, and I can also see how devastating it could be if the wrong elected attorney general were put in. There is some inherent protections when the governor appoints the attorney general that they do want somebody who has an excellent reputation for sound legal decision making, because they want that protection, they want that expertise, where I think, as we all know, campaigns can look very differently for that. So I struggle. I appreciate the merits. I think, again, either situation is not ideal, and it's kind of the devil you choose. But I appreciate bringing the bill and the continued efforts, and I don't think it's wasted time to continue to discuss it. And I struggle. So I think it's important for the body to know that. I'll probably be a no vote, and the basis for that is I don't see how this couldn't be significant financial cost. Again, I'm confounded by the fiscal note. But.
Thank you. I'm last, and as usual, my lawyer spoke for me pretty well. I think Senator Nethercott represented a lot where I'm at. I've been supportive of it. I think it makes some good sense. I am really, really torn on it, particularly at this time. I think the financial end is difficult at best. And it is. There's good merit to it. I've spent some time with the sponsor on it. I was hardcore opposed to it a year ago, and the time before. I have softened somewhat. So with that, I think we're fairly well through. Any more comments?
Just one follow-up, Mr.
Senator
Chairman.
Endicott?
I would like to thank Senator Bouchard for the work on the bill. I do think it's been thoughtfully done, particularly as it relates to what positions the Attorney General appoints, and which one the governor remains appointing. The removal, I think, of the Attorney General from the SLIB board, I think is prudent and thoughtful and correct. And so I think the bill is a lot of consideration went into it.
Further testimony? See none. Question on the bill, roll call.
Senator Boner,
Aye.
Senator Case,
He did not leave a vote and said he didn't want to, so
so excused on Senator Case.
excused, yes.
Senator Nethercott,
No.
Senator Scott,
No.
Chairman Driscoll.
No.
So Senate File 86 fails, 3 noes, 1 aye, and 1 excused.
It is 9:38. The next bill happens to be one of mine. I think it's pretty short. We are to unclaimed property deposits. So I could present the bill, but I actually think if he's willing that I will have Mr. Taylor come up and walk us through it, because this bill was the background on it was done hand in hand with the cooperative statewide at their request. I think it's a great bill for someone that lives in the cooperative world. This bill makes a lot of sense and it does the right thing. With that, I actually think that if you're willing, Mr. Taylor, and I didn't talk to you ahead of time, I think you can do a better job of presenting it with less chance of having a fact done wrong. So with that being the case, if you would like to proceed.
Sure, Mr. Chairman. Good morning, members of the committee. My name is Sean Taylor, Executive Director of the Wyoming Rural Electric Association. I do have with me today Mike Smith. He is our attorney. Our longtime WRA attorney, Dave Uechtner, passed away last fall. And we've hired Mike and his firm, and Mike helped me draft this. So if there are some drafting or legal questions, I might have Mr. Smith come up and give me an assist. But I guess I'm not very good at presenting the bill as you all are. I can give you the gist and the reason behind it.
If you would do that, I can work the bill page by page as it comes time.
Great. And I do also have Mr. Mike Easley, the CEO of Powder River Energy. He'll be zooming in at the appropriate time to kind of give you a little bit more background. And but to make this as simple as possible, years ago, and I think Senator Scott may remember this, the legislature, and this was before my time, the legislature passed a bill that allowed the cooperatives to keep unclaimed capital credits. Capital credits are basically the money left over at the end of the year. As you all know, the co-ops are not for profit. We put together our budget for operation and maintenance every year. And if there's anything left over at the end of the year, we return that to our membership as their financial stake in the cooperative. We call those capital credits. And years ago, we'd been building up, all 14 cooperatives across the state of Wyoming support this bill and experienced this with capital credits. We were building up large amounts of unclaimed capital credits because we weren't able to find the rightful owner. They moved on, never left a forwarding address. We tried, and Mr. Easley can probably, or maybe even Mr. Scott could, or Senator Scott could correct me, but I think we tried for 5 years or it's either 2 years or 5 years, I can't remember, to track down the rightful owners of the capital credits. With the bill passed for the capital credits, it allowed us, the cooperatives, to use those unclaimed capital credits to the benefit of our membership and our cooperative. This bill simply does the same thing for unreturned or unclaimed deposits or refunds. A member will give a deposit for any number of reasons. Once that deposit is due back to them, they The cooperative tries their best attempt to find the person or corporation or company or organization that is due that refund or deposit. And if we can't, currently those funds revert to the unclaimed property division at the state treasurer's office. We feel if we can keep those at the cooperative, again, after making a good faith effort to find the rightful owner, if we can keep those within the cooperative, we can better use those funds rather than just sitting. The unclaimed property fund at the state doesn't do anything with them except try and find the rightful owner, but they don't expend the funds for anything. We feel if we could just, like with capital credits, use those to the benefit of our membership and our cooperatives, makes a lot of sense.
Senator Scott.
My question is, if this bill should pass as it's written now, you have one of these unclaimed thing goes more than 2 years and you use it, then according to this, at year 3, somebody shows up and claims it. Do you say too late, you had to get it done within 2 years, or do you pay at that point?
Mr. Chairman, Senator Scott, it's a good question, one that we've struggled with when we were drafting the bill, or even with the idea of it. On the one hand, we would be willing to refund those deposits, but on the other hand, some of these deposits are huge, and they are from bankrupt entities that Mr. Easley may be able to talk a little bit more about. And in year 3, if they were to come back, the deposits are so large that it would almost be impossible. I don't know if I want to say impossible, but very uneconomic to the cooperative to try and return that deposit. So we kind of struggled. We set on 2 years. I think we'd be open for any discussion if we wanted to make that a little bit longer, but I don't think under this scenario, under year 3 or in year 3, if someone came forward and asked for it, if it was particularly large, it would be uneconomic for the cooperative to do that, to return that deposit or refund.
Senator Nethercott, questions?
I'll let Senator Scott follow up.
Well, Mr. Chairman, I don't have strong feelings as to which way it ought to go, but I couldn't figure it out from reading the language. And maybe that's just me, but my question, it really is, do we need an amendment that settles that issue clearly one way or the other? Because I'm not clear from reading the bill, and maybe I'm just not reading things right.
Mr. Chairman, Senator Scott, if I may, again, we're open to it. On page 2, line 3, it does say line 2 and 3, the cooperative for more than 2 years shall be determined to be unclaimed. So that does set the 2-year time limit on it. If they came back in year 3 under this, we would say, sorry, we tried to track you down for 2 years. Now we won't.
Senator Scott.
Mr. Chairman, yes, it's unclaimed, but my question is, so it's been unclaimed for 2 years, they can then use it, but does that mean that when somebody shows up on year 3 that they aren't entitled to it? And maybe I'm saying things that go bump in the night, but I do wonder if we ought to clarify that one way or the other.
Thank you, Senator Scott. Senator Nethercott.
Thank you, Mr. Chairman. Mr. Taylor, thanks for being here. Mr. Smith and Mr. Easley, couple of things running through my mind, and I've most often dealt with these in probate matters where in the amount that is going through the probate process that a decedent is owned or their estate is owed is fairly insignificant. So, and I'm unaware of those large payouts associated with what you've identified as bankruptcy. I see the operative language there, page 2, line 4, that after 2 years of it being unclaimed, there's this protective language, I think, for the co-op, that notwithstanding any other provision of law, and including provisions pertaining to unclaimed property, because I want to make sure it doesn't get, that this analysis, for your sake and your members' sakes, doesn't get lost in a concept associated with unclaimed property as opposed to the law associated with bankruptcy or any other ownership rights. Because you're severing ownership rights with the protective language of notwithstanding any other provision of law, which is certainly prudent. But then when we look down on page or on line 6, that subject to all other potentially relevant laws, unclaimed refunds for deposits or advance payments shall be used by the cooperative utility. And so I don't know if that's a good idea for you or not, and think that should be a may. I don't know, but I think it could be tricky, and might tell the co-ops that they have the right to do something when maybe they can't. And again, that's at your discretion and at you and your legal counsel's wisdom. But I think that there might be unintended consequences there that you may not be allowed to do something. Because if it's a bankruptcy, right, that money belongs to creditors, or someone else who has a legal right to it. And so the company declares bankruptcy, they check out. Now that process is in bankruptcy. No one's necessarily claiming it, but that doesn't mean they don't have a legal right to it. And of course, that protective language is there. So just something to think about. I have no real heartburn with the bill because it's kind of squishy, but I do think it might be dangerous for the co-ops that it's statutorily authorizing you to do something that you really can't do. So it's kind of meaningless. But that's your call.
Thank you. Senator Boner.
Okay, and assuming that, I guess there wasn't a question there, so I'll just proceed. Mr. Taylor, so it'd be helpful to me to kind of piggyback off what Senator Scott said, understanding just how much we're talking about here. Do you have any information as to how much of these payments your members turn over to the treasurer's office, and also how many of those funds are reclaimed at some point from the treasurer? Just some help here, understanding what the real impact would be helpful. Do you have any perspective?
I think
on that?
Mr. Easley's prepared to testify.
Yeah, Mr. Chairman,
Okay.
Senator Boner, Mr. Easley, who's up now, I think he has some data on that. And then I wouldn't mind coming back and having Mr. Smith join me to address maybe some of Senator Nethercott's.
You'll be welcome to do that.
concerns. Thanks.
If we can get Mr. Easley up, we would be more than happy. Welcome, Mr. Easley, and thank you for bringing this bill. It's good for our co-ops, or helping with it.
Thank you, Mr. Chairman and committee. My name is Mike Easley. I'm the CEO of Powder River Energy Corporation. So we're the electric co-op serving the 5 counties in Northeast Wyoming. We're the largest co-op in the state, probably the second largest utility, although with some of the declines we've seen, that may not always be the case going forward. But in any event, Precorp is speaking in support of the bill. And Sean gave a good sort of a good recap, but I have just a few things I'd like to maybe just underscore with my comments. First of all, at the heart of cooperative philosophy is being member owned and local controlled. And right now, as Sean mentioned, the capital credit process that we have basically is a way that we ensure that we're not for profit, because over time we return those margins back to the members. The way that process currently works is if those members, if we can't find them, then those dollars, there's a process for those dollars to eventually come back to the cooperative rather than go to the state. What's interesting, and maybe it's a nuance that we haven't really highlighted, but when we send a member a check and that check goes to an out-of-state address, were it not for the laws that allow us to currently treat unclaimed capital credits as we do, those capital credits would actually go back to the property in that state. They wouldn't be Wyoming. They'd actually, if we're sending capital credit checks to Texas or Colorado, and we didn't have a process to claim those back for us, those would go to those states, I think. And we've actually have had some property that wasn't related to capital credits that we sent to other states. Texas comes to mind. They had there was a customer whose last address was in Texas. We did some refunds, and we ended up not being able to find them and ended up having to pay that back to the state of Texas. So there is a pretty tried and true process for capital credits, and that's been something that all the co-ops in the state have used. That particular account for Powder River Energy, we have about $4 million in unclaimed capital credits, and that goes back to inception of the co-op. So the number is not huge, but it's when you compare it to the overall equity of the company, $300 million asset base, it's not a huge part of that number, but it's still very meaningful. And we typically co-ops, have each of them vary a little bit on how much capital credit they actually retire every year. Precorp does a minimum of $2.5 million that we put back into the members' pockets, or we try to. And when we don't collect on those, we have a 2-year waiting period, and then we advertise for a year. So it's usually about 3 years before whatever is unclaimed on capital credits, before that is able to be put to overall good use for the members. And so on the capital credit side, Precorp tries to budget about 4% of that $4 million. And we do things like we use it to fund our stock purchases at the local fairs, the 4-H stuff. We use it to fund scholarships for high school kids and throughout our service territory and all the schools. We have a committee of employees that does charitable giving in the communities, like supporting post-prom activities, those sort of really small things in the communities that really mean a lot. And so we make pretty good use of those that 4% balance of that $4 million unclaimed capital credit account that we have. The revenue leakage that's outside of capital credits, it's a much smaller number. Although from Powder River's perspective, the future of that could get more than what we've seen historically as CBM begins to unwind, and some of the funds that we have retained to help us mitigate the risk of the CBM ultimately having to be retired. Some of those numbers could get a little bigger than what they have historically, but we've seen around $10,000 a year in revenue that was not a capital credit. And so then the scale between what we're seeing in capital credits and what we would see in this other approach, they're very small compared to the capital credits. But at the same time, every dollar that we can keep in Wyoming and every dollar that we can keep, turning around the economy in Northeast Wyoming, we think is really important. And so that's why we support the bill. It certainly, we envision it as being just the same sort of a process as what we have for capital credits and how we go about retaining those unclaimed capital credits. And we would go through that same process and do basically the same thing, and it would just fall into that same process that we use for verifying those unclaimed capital credits. So we speak in support of the bill. I hope that some of my comments did not make the dialogue even more confusing. Kind of in summary, it's the similar process as we have for capital credits to keep the funds local, keep them in Wyoming, keep them in our service territory. The dollars are much less significant than what we have on the capital credit side, and we would just encourage the committee to ask any questions that I may be able to answer and help clarify if I've created any more confusion than what I intended to do.
Well done, Mr. Easley. Thank you. Questions for Mr. Easley? I think you helped understanding a whole bunch, so thank you very much. Appreciate the testimony. Probably have you hang close if we come up with a question, if you would. Thank you.
Absolutely.
We'll jump back across to see we've got Sean
Sure, Mr. Chairman, I'll just follow up on one thing that Mr. Easley said, and kind of to your point, Senator Boner. They're the biggest co-op. So that, and even at the biggest co-op, the dollars we're talking about aren't significant, but they're going to be dealing with some larger ones, in the coming years. So as you move down the scale of the size of the co-op, this is going to mean much less in terms of dollars, but still, as Mr. Easley said, anytime we can keep that within our local communities, the better, provided we make that good faith effort. And then I think Mr. Smith might have some clarification to Senator Nethercott's concerns, and maybe Senator Scott's as well.
Perfect. Mr. Smith.
Mr. Chairman.
Identify yourself, what you do, and take off.
Thank you, Mr. Chairman. My name's Mike Smith. I'm an attorney here in Cheyenne and representing the WREA on some legal matters this year. Mr. Chairman, I'm cognizant of the time. Let me just real quickly address Senator Nethercott's questions on the shall versus may. That really was an attempt to mirror the existing language in 1301 on capital credits. And it's about, I agree with you. They ought to have it shouldn't be a must do this. If they have extra money, it's at their discretion. But I think the existing law and this amendment to it would be trying to give some assurance that this money is going to be directed towards benefits of the membership. And that's why the shall was in there to make sure that it's not being spread around. As to bankruptcy, I would hope that any co-op would have access to those records and understand, okay, there's a pending bankruptcy. We need to let that play its course. We're not going to go throwing around the money. And but if they research the issue and it's unclaimed property under the statute, it's been through bankruptcy, nobody had it. I don't know that process. I'm not that intimate with the bankruptcy laws, but it gives me some assurance that they wouldn't be racing to pass out money if there were a pending action. And Mr. Chairman, to Senator Scott's question, it's an excellent one. The LSO bill is silent on it. I agree. They don't make that clear. There's an existing authority granted to marketing associations, co-ops. That's in 1710-235. And at the end of that statute, they explicitly say the right of an owner to unclaimed property held by a co-op is extinguished when the property is dispersed by the cooperative. And that's, Mr. Chairman, getting at Senator Scott's question. And I don't know Sean's organization's position on such an amendment. I assume you'd be friendly to it. It makes some sense to just be clear that once this money goes out the door, it's gone to a community organization or to the members and their interests. And we may want to clarify that that's been extinguished in the original party. Thank you, Mr. Chairman.
Thank you, Mr. Smith. That answer your question, Senator Scott?
Mr. Chairman, frankly, I'm considering amending it on page 2 after line 8, add the words after cooperative, and if subsequently claimed, need not be refunded at the cooperative's discretion.
One more time, please.
Okay. After cooperative, insert and, comma, if subsequently claimed, comma, need not be refunded at the cooperative's discretion. So that would make it clear that it's up to the cooperative after that 2-year period.
Makes good sense to me.
I recognize the hour, Mr. Chairman, so I don't want to be too laborious here, but what if we just left it at and shall not be refunded? And take out the discretion of the cooperative, and thus that shall concept remains. But certainly if the cooperative wanted to, they could do whatever they wanted. So we don't necessarily need that statutory authority, but looking for feedback on that, Mr. Smith.
Mr. Chairman.
Go ahead, Mr. Smith.
Senator Nethercott, I'm kind of agnostic on the two approaches, honestly. I think either would get done what you're trying to accomplish. Just looking at it on the fly. I guess I'd be worried a little bit if you do include shall in that phrase, then the co-op does wonder if they have that discretion. So I think with apologies if I think about it longer later and want to change my mind, which happens a lot, Mr. Chairman, I think I would prefer Senator Scott's approach of stating the discretion is in the co-op.
Mr. Chairman, if I may, I would agree, because we did have conversations within the different co-ops, and we had one co-op say, well, if this person comes back after year 2, we would be willing to refund that. But they're one of the co-ops that won't have one of these big deposits and could probably handle it financially. So I think giving the co-ops the discretion, I don't disagree with Senator Nethercott. Maybe legal nuance that, but I think maybe make it clear with Senator Scott's that the co-ops have the discretion if somebody does come back in year 3 or year 4, that they can still refund it. And it's, again, if we're talking the big dollars that Mr. Easley was talking about, that makes it a little bit more problematic.
Right.
If we're talking about these small deposits and refunds, I don't think it's going to be problematic for any of our other cooperatives to
Mr. Chairman,
give that refund.
I intend to support Senator Scott's amendment as he proposed. Just another piece to think about, because I'm really not coming at it from the legal perspective necessarily, but more also of a practical, from the accounting side of it, of holding that potential liability on the books of, is it or is it not in this column or that column, or is it still a may at the co-op's discretion return 1.5 million? I mean, I don't know. So just, it's more of an accounting question or a accurate books question as opposed to a legal one, as a result of the shells and at the discretions. So just something to think about, but I'll support Senator Scott. I second your motion, Senator Scott.
Mr. Chairman, I so move.
Thank you. We also got another 4 or 5 bites to the apple. If this looks like it's not there, this is inning 1 of a long race. So you folks have been through that. So we'll have to move the bill before we move the amendment, which I don't think we've done.
Okay, move the bill.
Okay. And I need to see if there's any more public testimony real quick. I get that, but I can't
We
not.
did start 20 minutes late, so.
Mr.
So-
Chairman, there is a Mr. Jeff Robertson in the waiting room.
Let's put him up. We're gonna have to take care of people or lay the bill back, so. You want to lay it back, Senator Scott?
Yeah, we need to be upstairs.
Okay. Mr. Robinson, are you available to come up on our next meeting on Thursday?
Mr. Chairman, fellow senators, I will be available, yes.
Okay, 'cause we are out of time, and I think we'll put this top of the list. We're actually snubbing the governor by not doing this, so